I'd like to call the meeting to order of the Board of Leavenworth County Commission. We'd like to invite everyone to stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For the record, all three commissioners are present. We'd like to open up with public comment. Anyone from the public wishing to speak, please come forward, state your name and address. Seeing none, we'll move on to administrative business. Mr. Lawfrey.
We do have the announcement of the Employee of the Month. It was scheduled for next week. However, the department is going to be out that day, so just asked to handle it today.
Commissioners, this is Lisa Crook. She's been in the treasurer's office for 30 years. And as of
Wow.
she started in 1987, and she has worked for 3 county treasurers. First, Shirley Tate, Janice Young, and now myself. So she's a real asset to our office, and she's a great employee. So
I appreciate the long-term employees.
Yeah.
There's no substitute for experience.
that's right. She has a lot of knowledge. So anyway, I just wanted to come up and introduce her, so everybody knows who's talking to the spot.
All right. John, you gonna get a picture? Or you don't have
We're
it?
going to take a picture and send it to him because I kind of
Okay, we sprung it on
screwed up
John.
the agenda,
Okay.
so.
All right. Well, thank you, Lisa.
That's all I had.
All right. Then, as commissioners had a chance to look at the minutes,
I have. I'll make a motion that we approve the minutes as stated.
voting. Aye.
Aye.
And the agenda for next week to have our 2 sessions on Thursday because of the holiday.
Motion to approve.
Voting.
Aye.
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 Okay, and then I have some OCVs.
Motion to approve to have the chairman sign and date the OCVs.
Voting.
Aye.
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 Okay. I believe we're ready for planning and zoning.
Good morning, Mr. Chairman, members of the Commission. The first item is a request to implement a fee for boundary line adjustments. We recently changed the regulations to where we opened up that process to, in lieu of all the plats that are required. So we are getting a lot of applications. So our request is to implement a fee of $200 as an application fee.
And the boundary line adjustment is taking up some of the just regular lot splits.
Correct. Yeah, we changed the regulations to where it opened up for more boundary line adjustments in the future, so they can come in and change the boundaries instead of platting it.
Okay. And
So-
that speeds up the process.
Correct. It's only like 1 to 2 week process. It's also reviewed by the county surveyor and planning and zoning staff.
Okay. All right.
Motion to approve.
Voting.
Aye.
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 The second item is to increase the engineered septic system compliance deposit fee from $125 to $500. I kind of explained it last time when I came in for my quarterly report. Basically, we are not getting all the as-built drawings from the engineers because it's only $125, so they're just letting it go. And so we're having some problems collecting all the drawings. So with the $500 fee, I'm pretty sure that we'll be getting more
I'd say so.
inspection drawings back.
So now how much of that would be refunded then?
It'll be the $500.
Yeah, the whole
It'd be a bond.
500.
It'd be just a bond.
So if they don't bring it in, then they don't get a refund?
Correct.
I'd bring it in.
Sure seems like quite an increase, but I can see the purpose of getting it.
I do too.
Is
It's
there
quite an increase, but as I look at it, they get their money back if they do the job like they're supposed to be doing in the first place.
Do you have a list of those that you would accept as built drawing?
Yes, we have a list of engineers that they can do the work in the county.
Now, they have to go by this list. They can't go pick their own engineering.
Well, they can pick the engineer, but they have to be licensed in the state of Kansas, and they can add that engineer into the system. So we'll
Now,
have
this is only on new septic systems.
correct.
Right.
Okay.
Are there older septic systems? Are they grandfathered in? I mean,
Well, the problem right now is, we're not getting the drawings back from the engineers, so we're trying to get them to give us the drawings, but we cannot go back and get that fee from them. It's not possible. So these are for new applications.
How long would you hold the bond before you kept it?
As soon as they give us back the
So
drawings.
2 years later, they could bring in their as-bills and get
Yes.
their money back?
Yeah, we have a database that we keep up
Okay.
and we check every
All right.
every month.
I move approval.
I'll second it with one more question. If you hold this for any length of time, are you going to, say somebody comes in and writes you a check for $500, how long do you hold that before you cash it?
Well, we immediately submit it to the clerk's office.
Okay, so it's cashed immediately?
Yeah.
And so it would be a refund?
It'll be a
then?
refund, yes.
Okay, rather than just giving back their check, because you have,
Mr. Chairman, members of the commission, I hate to break in. I think
Yeah.
Commissioner Holland has a very valid point on the table. He has seconded the motion, so if you would indulge me to as part of the discussion. Holding refundable accounts can cause bookkeeping problems for the county, but I think more importantly, the issue is that plans for a septic system, one, exist, and two, that those plans can be located at a future date. I know from personal experience, finding the septic system plans for a house I looked at to purchase that had been built in 1973. Planning zoning commission had it.
Mhm.
that was the reason I was bringing this up, because I said we can't just hold all these checks. We have to cash them, and
If I
it's a
could offer
refundable.
A suggestion. If the board wishes to change its policy with respect to fund or the refundable account, or reimbursable account for septic system plans, particularly design-build plans, which could be contemplated, that a $500 deposit be applied, and that the plans be submitted within a date certain after we don't have certificates of occupancy. In other words, 2-3 years doesn't go by, a subsequent buyer has purchased the property where the engineering firm has disappeared, and we're out, because the plans are worth more than the $500.
Right.
So you may want to set a date that from the date they make the deposit to the date they come to apply for the refund of the deposit is set out,
Exactly.
to encourage that the plan be prepared, and to that our planning department be provided a copy.
Your building permits are good for 1 year.
Yes, sir.
Is that something we should tie it to then?
That
Yes.
sounds reasonable.
1 year from application?
For that.
Would that be part of your motion, Commissioner?
You'd have to amend the.
Can we amend that motion?
Well, we need to rescind the motion.
Rescind the
and then-
motion.
And then,
I'm wondering, are we giving too long a time to get the design in?
Well,
because,
their building permits are good for a year. I mean, people come in and get their building permit, and then they're waiting on contractors and subcontractors and everything. I think a year is reasonable. I mean, that's my opinion.
I think so too, and Doug's got a good point, because you have to wait for subcontractors, and if you're in a busy season, you've got a contractor lined up, and he said, well, I've got this house and this house to build yet, and I've got to do all this and this and this, and this guy's already got his building permit, and he's got to wait till he gets the builder he wants to build his home, and so it could run into as much as a year.
Do you allow for any extension on a building permit, like a one-time?
Yes, if they started the construction and then we let them finish it.
Okay. So we could just tie it to the building permit
Right.
rules and regulations. Would that be acceptable?
Yes.
So your motion would be to allow 1 year for the bond to be
I
returned?
understand the saying if
The same as a building permit?
If conditions indicate it's necessary.
Okay.
Second.
Voting.
Aye.
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 Thank you.
Thank you. Ready for human resources?
Good morning, Commissioners. Tamara Copeland, HR. I'm here to present the quarterly report for Human Resources Department. For the second quarter, for employee totals, we're up to 430 employees. It's about 10 employee increase from the last quarter. That's due to summer hires. The turnover by departments, we try to maintain a quarterly goal of 2.5% to 3.75% as a quarterly goal, with an annual goal of between 10 and 15% because these are normal standard averages. Currently for the second quarter, we did have 14 positions turn over. It ended up being a 3.2% or 6% of our goal, which is right in that frame that we're looking at. We did have about 9 voluntary terminations. We had 2 involuntary terminations and 1 involuntary termination for other. That's that category that we created last quarter that is basically for those ones that are a little bit out of the norm for an involuntary, such as a layoff, because of the law, a law change that required us to let a position go. It could be because of grants ending or job ending. It could be because we've had a deceased employee. As far as the turnover and the departments that are most impacted by that, it's the Sheriff's Department and the Public Works Department. That's typically normal. Usually EMS is sometimes in there, but they got lucky this quarter. For workman's comp, we have a 2017 rate of 0.76%. This is a decrease of 10% from 2016. As soon as we get done completing our fall audit, which will be happening any time now, we will get notified of our new 2018 rate. We're not sure what's going to happen this year because we did have some really high claims last year. So we'll just have to see how all this is impacted. We have a cumulative total of 13 worker comp claims. This is trending about average. If you look at last year, we only had 18 for the year, which is a really great year. It's just that some of those were really high claims. Prior years, we've had up into the 30s. For our incident report tracking, we have a cumulative total of 25 incident reports. This is trending high, and some of these accidents were very expensive. So that's something that we try to watch, we try to mitigate. The safety committee does a really good job of working with departments to try to reduce accidents and injuries and try to mitigate those risks. So, you know, hats off to them. They do a really good job, but sometimes things happen. As far as FMLA tracking, we have had 16 FMLA claims for the second quarter. This is a cumulative total of 32. This is also trending higher than average. It means that we have a lot of FMLA qualified events occurring within the county. We have a population that's growing older, so of course they're going to have more surgeries and those types of incidences. We also have a younger population that may be having children. So that's what creates it to go, usually for it to go up and down. Regarding the Kansas Department of Labor, we just received our 2018 rate. It went down to 0.19% from 0.22%. This is 3 years in a row that we've been able to drastically increase that rate, which means we have a significant savings in what we normally pay out to Department of Labor. This is great for the county. Regarding the HR budget, our goal for second quarter is to be at 50% or less. We are at 45.34%. This is about a 4.66% under budget, so we're doing good there. This is one of our busiest quarters other than year end. So we've been extremely busy addressing insurance, solidifying insurances. We have attended the several Kansas Eastern Regional Insurance Trust Board meetings. We've also attended several ADP trainings that they give to us. They're free, so we try to take advantage of those. It helps us learn the system better. We also have been very busy with open enrollments. We just conducted 4 open enrollment sessions. We had very good turnout. We are now gathering all of the forms from all the employees. They're doing a great job of getting them back into us. Today we're going to be going through and finalizing the list to see who we are still missing and see if we can get those forms in so that we can get that process going. We only have about a 2 to 3 week period to get everything in the system and up to date, so it'll be very hectic in HR for the next few weeks. I think that is it, unless you have any questions for us.
I do. On the KDOL rates for the annual total cost, back in 2014, I read across there, and I guess it started out in 2014, 139,402. And in 2017, we're down to 35,772.
Yes.
It's that much of a drop.
When we've dropped from a rate of 1.05%, which that's, on
Right.
millions of dollars, that adds up. And we've
right.
gone down to 0.22 last year. Now we're down for 2018, we'll be down to 0.19%. So there'll be additional savings.
And how many years do they go back on claims and stuff?
Well, if somebody's in that period, they can
Uh-huh.
always come back, because sometimes we have it happen where somebody has left us and they did not have a claim with us, they just went on to a new job. But then when they go on to another employer and say it doesn't work out with that employer, or they get fired or whatever, and they file for unemployment for that employer, if we're still in their base period, we will get notified. But what we are doing is, if they left us on positive terms to where we're not responsible for unemployment, we make sure that we follow up on that claim so that we don't accidentally get charged with that, because they initially send us a notification saying, hey, you're going to be charged for this because you're in the base period. We make sure we're filling out the documentation, say, hey, wait a second, this person left for this reason, it doesn't qualify, so they won't charge our account for that amount.
Okay.
Another question, I want to back up here to the original. It's the unemployment, or the, let's see, I got the wrong, workers' comp, that's what I wanted to ask about. I had a friend that worked for the government. He retired, and he still was, he couldn't take Social Security, Medicare, all that. So he went down and filed for unemployment and got it. Is that the same thing with the county? If someone retires, say yourself, if you retire, you can collect unemployment, or
We actually had that happen this past year. We had some public works employees retire, not you, but we did have.
I missed my check.
Yeah.
Yeah,
We
that's
did,
what
but
I was wondering. Are you getting 2 dips here?
Yeah.
It depends on the scenario. For example, this person was working, but the job ended for the year. They also were retiring at the same time. They were able to collect unemployment.
No,
It depends on the scenario.
Oh,
Workman's
okay.
comp, they would not be able to unless there was a work comp injury.
No. Okay. I just kind of thought that was kind of odd. You retire and you get paid unemployment.
It depends on how you retire.
Yeah.
The system's not perfect.
Yes.
No, I guess not.
Yes.
For some people it is, so I guess.
Yeah, I guess so. Okay, that's all I wanted. I
Okay.
had those 2 questions.
Any other questions?
No, I move that we accept the quarterly report of human resources.
Was that mean improving the?
I think we were going to talk about that as a separate item. We can do that now.
Yeah, let's talk about that now.
Okay. The second item is basically it's the county's flexible benefit plan. Every so often we need to get this reviewed and looked at because there are different changes that occur. So you should have a copy of the updated flexible benefit plan summary. It has been reviewed by the administrator and legal. What we did for this was we needed to get it a little bit more up to date because there were some ACA and HIPAA changes back in 2014 and 2015 that allows for more items to be addressed as part of open enrollment. So, and basically our cafeteria plan is governed by the IRS Code Section 125, and it does allow employees to help pay for their expenses and health insurance as pre-tax dollars. And only certain benefits can actually be offered through this cafeteria plan. And so our employees are allowed to choose these benefits by making elections on an annual basis, which is what we just got done doing through open enrollment process. So what we did for this plan was we added some more options on there to clarify some things and make it a little bit easier for employees because there are additional items that actually make them eligible to make changes mid-year, and that's usually the biggest issue. So on this particular document, we have added the county's flexible spending account for medical independent care, which was what we added in last year. We've also added criteria for to address all the Affordable Care Act changes. Those are those items that I had listed out and highlighted in yellow that kind of shows some additional things that we can do mid-year that helps out employees, such as change in coverage of spouse-dependent care. This was a big issue because what happens is we have our open enrollment period in October, but somebody else's might not be till December or January. This clears it up in our plan that allows us to make changes mid-year. So if their employer has a better insurance plan than ours, they could get off of ours and go to their spouse's. Or if they find out that their spouse's rates went sky high and we have a better plan, they can get off their spouse's. But since our enrollment's already closed, they can have a qualifying event to come back onto our plan. That's a very good benefit for the employee. So we made sure that we got those things in there. It's also one of the ACA requirements to make sure we identify when there's entitlements for Medicare and Medicaid, any sort of reduction in hours because there's a special qualification for reduction of hours through the Affordable Care Act, and also just to address any mistakes that would be made. Sometimes employees think that they're doing one thing and it ends up being another, and if we can deem that it's an actual mistake, or if we made a mistake, we can easily make that correction with the insurance companies without causing a problem for the employee. So some of these changes will definitely help the employee. The other thing is just to clarify the benefits available to retirees, which is the other section that was added and highlighted. We wanted to clarify this because your cafeteria plan, when you offer benefits to your retirees, there should be a clause or a statement in there that identifies how you handle that process. We had a process in place for quite some time, so we basically documented that process. We've also worked with our interns to find out who allows what. Most of them follow our process. I think there's only one that would actually allow somebody to come on at a later time, but usually because of COBRA rights and other types of entitlements, retirees, they get an option when they first retire with us, and that kind of sets what theirs is. They can always drop insurance and they can always reduce it, especially if there's a qualifying event mid-year. So for example, if somebody lost a spouse, or the spouse gained employment and has insurance and they had family insurance with us, they could reduce it down as a qualifying event down to a single plan. So this puts in there what we've been doing so that we have it established. So this is kind of our guide for our employees so that they know what benefits they actually have available to them that fall underneath the cafeteria section 125 plan.
Okay.
And so what we would need, or
This
what
is
we're
no
asking-
different than what Kansas retirement tells people when they retire, that
Yeah.
as long as you've been with your employer for 10 years, you can stay on their plan as long as you pay 100%.
Correct.
That is pretty much what they
Pretty
do.
much the same.
Right.
And we're not changing really what we currently do. All retirees have COBRA rights, so they have a period of time within the COBRA process to address things if they had qualifying events also.
Mhm.
So this is a pretty standard process, and we really just wanted to get it up to date, so it's really reflecting what we're currently doing.
Okay. And we would never in the future try to get a plan that wouldn't allow retirees on, I would hope.
Right now, I think with the Affordable Care Act, that is a requirement that they need to try
I was
to
gonna say, I
allow.
thought that
Well, I mean,
was
the
before.
COBRA,
Right.
18
Right, I mean,
18
there's always the
months.
COBRA rights.
Right, but that
yeah,
only
that's-
takes you 18
What are you
months.
thinking about getting older or something, Doug?
I sure am. Just did this week.
Oh, that's right, you
Clyde
did.
and I both just got a little older this week. But,
That would definitely be something to always pay attention to
Right.
when we are doing insurance reviews, that we are making sure that they will offer what we want to offer.
and I understand everybody in this room wants to hold their costs down on insurance.
Right.
And Jamie Miller was in here the other day on about health assessments. Is there any way we can do the county-wide, do health assessments on each employee to try to get a better insurance rate?
They tried doing that back, I'd say about 5 or 6 years ago, and maybe 10 years ago. Even the state tried doing it. It failed miserably because a lot of times trying to get employees, they would want to go see their own doctor, and the process wasn't set up very well. But I know that maybe 4 years ago, it was prior to me coming on board, I believe they were trying to do something similar to that, like to add some sort of wellness check on an annual basis that would help reduce the cost, or possibly even looking at, which this gets to be a touchy subject, but you start looking at people who smoke and those type of things, and if we would offer different discounts to those types of things. It was highly unpopular with our employees, but it was being looked at, and I think Blue Cross and Blue Shield looked into it for us, but I don't know what happened to it. I don't know if they just decided it wasn't something that they were going to do and pursue, and or if they would be willing to continue to do something that in the future.
Well, the health assessments that I was, have heard about were the ones where employees go and they get their blood pressure and everything done. As long as they do follow the maintenance program put out by their physician, you don't get pinged. You actually, you get a discount.
I think we wanted to see how the screenings went this year voluntarily by adding the new features that we're doing with the stroke screening, see how many people participate. And if we don't get the participation rate we're looking for, then obviously we will talk about other options for that. But I think it will actually be filled up. I don't think we'll have enough slots available, and that's the next thing we're going to evaluate is if we need to do a 2-day.
Okay.
We'll want to see how this year goes. But yeah, I think that's a good idea. That
I think we need to be looking at every option we can to lower
Yeah.
health,
I
because that's a
know,
big
I think
cost
so
for the
too.
county. And
yeah, I've been part of a program where
Totally.
you had to do those screenings, and if you didn't, then you had a different premium than the other employees did who did participate. So there's a
Well,
big
that'd be
incentive.
nice.
There's a big incentive for the employees to go participate, at least do the screenings. At least do the screenings.
And an option to that also, because some people really do not like to go to those screenings, they would have another option, which might be something to consider as part of this process, is if they don't do the screening, but they did their annual preventatives that did the same type of thing, they could take that form to their doctor and actually get the doctor to sign off on it, showing that they actually did the screening, but they did it with their physician, and that qualified for the same premium discount, which is a very good thing to include as part of the process, because it helps those employees that don't want to go to some line of people and have their partner, their neighbor, whoever, their coworker hear, because you always hear stuff that's going on. This allows them to work with their particular physician and do it privately.
Okay. Question, Mr.
Cameron, I'm sure it's in here, and I didn't see it. A retiree retires. He can retain his health insurance through the county. But if he drops it, he can't come back on again.
If they actually drop the insurance, they cannot come back on to that particular insurance. Basically, you can take the insurance that you have, whatever that is, and you can reduce it, or you can eliminate it altogether. But once you've eliminated it altogether, you cannot come back on it. And that's because you've elected to go off and change your original plan.
Thank you.
Any other questions?
No, I've answered, everything's been answered as far. I wonder, well, I did want to ask David a question.
Spelled out.
Did you review this? Okay, I saw where it was reviewed by legal, and I want to make sure it was you.
And we do that at orientation. When a person retires, we go through that retirement process with them, and we explain to them as part of the retirement, when you make these elections, this is what you will have going forward, and that you can reduce them, or you can change them due to a qualifying event or add an open enrollment time frame. You just can't add or increase.
Okay. I guess if a retiree, at the time they retire, we are only offering a 2-tier, family or single, and then say 3 or 4 years down the road, we offer a 4-tier that, employees and spouse or employee plus one. Is that, will they be able to do that?
It depends on if they're already on a family plan,
Mm-hmm.
and say they want to go to a family plan that's just the spouse, which that's a lower rate, that's decreasing, so they could do that.
Okay. Do you ever see us going to a 4-tier?
I think it would be something to look into. It's what people ask for. I know it's offered in a lot of other places. We have not been able to get that option as of yet through our current process, but it is definitely something to look at.
Oh, I'm sure we can get it. It's just going to cost us.
And it does. I think
Yeah.
it does cost a little bit more to separate it
I
out
think
like
you're
that.
exactly right. I think we
Because
can
we
get
have it
it,
with vision.
Mhm.
Our vision, we have a
Right.
tiered
but it is going to
process.
cost.
Right.
But you kind of got to look at your employee situation
Right.
too. Of how many you got single with one, or just single with spouse. Or,
And there's a lot
there's a
that
lot
are in that
of people
category.
that have to provide health insurance for child support, stuff like that too.
Yeah, I would love to see, especially the one that's single and spouse.
Yeah.
I think there's a criteria based on talking with employees, that's a criteria that would be very helpful to have.
We got all year to work on it.
Yep.
So, any other questions, Ms. Colton?
David, did you want to say anything?
Just that analyzing healthcare for your employees presents you with an almost kaleidoscopic problem.
Mhm.
You're not done with it.
No,
No.
but unless the legislature changes the statute about, staying on your employer's health insurance after you've been there 10 years and you retire, and see any big changes here,
No.
as long as we follow the state statute.
Right.
And then, of course, the federal,
Oh, yeah.
so, as long as we're in compliance. So you need approval,
Yes, sir.
Motion to approve.
voting?
Aye.
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 Thank you, commissioners.
Yes.
We're really on schedule today, a couple minutes early.
Yeah. Do we have to, I was going to ask David this, what is the next IRB overview?
mhm.
9:35, do we have to stick to the time limit on this?
I would encourage you to do so, Mr.
Right, because I don't know if anybody wants to listen to our,
For the sake of certainty and caution, I think.
Especially when it's just a couple minutes.
yeah. 9:33, yeah.
Just a couple minutes. step down.
They're just making a couple of copies.
Okay. Thank you. Oh, okay. All right.
All right, got this.
They've added a
Oh,
paragraph.
so this is trash.
Are you ready?
We ready?
Yes. I'll start this off with the discussion, and then I have Mr. Van Paris here, and then Gina Rykoff with Gilmore Bell to answer questions and maybe to go in a little further detail. This is I think the RVA does a good job of explaining that this is basically a third leg of the agreements that we started on Monday for the water and the gas agreements that were approved Monday. This is an agreement that basically states that the county will move forward with the process in considering IRBs for the potential development in the south part of the county. I think there's a better description in the resolution on where those locations are, but I think the maps that we looked at on Monday actually showed it specifically where they are. The IRB process allows us to do a couple of things. One, the developer could issue bonds if they'd like to as part of the process and on an open market, or they can purchase them themselves, which right now that is their intention, to purchase their bonds themselves, which allows them to take advantage of some financing, but also it allows them to utilize the tax abatement process, which is available in IRBs. And that's really the gist of what these agreements are for. The developer would like to take advantage of that. This resolution is just saying we support that, and we will move forward with putting into place the necessary development agreement, conducting the necessary public hearings, doing the necessary bond issuance, and doing the necessary financial review for the return on investment, basically, for the county. So all those things are yet to take place. That is not what this resolution is. This is more a resolution of our intent to move forward. But we wanted to call out specifically what it is that they're looking for as we do move forward. The developer has asked for an 80% tax abatement on the ad valorem taxes that are eligible. And the way that works is they get a 100% tax abatement, and then they pay a pilot, a payment in lieu of taxes, back to the taxing entities of approximately 20%. In discussion with Gilmore and Bell, what that will probably look like is an actual, we will call out a specific amount and put it in there versus the 20%. That way, if there's any confusion or debate later about property valuation, it is clear to them what they will be paying us over that time frame, us and all the other taxing entities. I should be clear about that. And I would say that even with the abatement, so that people understand that maybe the impact of this project, even with the abatement, they will still be paying somewhere between $1.3 and $1.5 million in ad valorem taxes to the taxing entities, or payments in lieu of tax. So it's a significant increase in revenue for all the taxing entities in that area, even with the abatement. And with that, I would leave it to Mr. Van Paris and Mr. Rykoff to maybe go into further detail and answer questions that you might have.
Good morning, Commissioners. As Mark mentioned, Ms. Gina Rykoff from Gilmore Bell is present, basically our bond counsel, and providing information to us. She's here to answer any questions you may have, and ready and willing to. This is a significant issue, so I'm sure you may have questions we'll be happy to answer. As Mark pointed out, this is the third leg of the triad. The first was an agreement with Atmos Energy regarding the provision for natural gas on the site. The second was with Suburban Water for the provision of an adequate water supply for the site. This third leg deals with the notice of intent to issue industrial revenue bonds. Now, we haven't gone that route. I know Commissioner Graber is familiar with industrial revenue bonds. The simplest way I can caption to you is your name's on it, but much like the Trump Tower, you don't own the obligations or debt. The bonds would be issued in your name, but they are entirely market. You don't buy them. If somebody wants to buy the bonds, they're free to. And I can assure you that those bonds aren't going to go on the market unless there's a ready, willing, and able buyer. But it does allow a project of this scope and magnitude to find financial incentive and to benefit a municipality. And I think that's really the road we're heading towards on this, we're going down on this. The one thing Mark did allude to, and I think it's very important we note, is, as I point out in the next to last paragraph of my RBA to you, we've got the triad, and the base mechanism will be put in place, but there will be development agreements to hire out, cost-benefit analysis studies to be done. You will be seeing this on an ongoing basis as steps need to be taken by this board to make this project bear fruit. You'll need to conduct a public hearing on the IRB. We'll need to have various negotiations. Certainly this could impact other municipalities in the county, so we'll need to be prepared to not view this as something, a one-off time that you'll sign it and notice something appeared on the horizon. But I think this is a worthwhile goal. This offers a significant, I'll use a lifetime opportunity to this county. And I don't want to turn this into a mutual admiration society, but you really owe thanks to Mr. Lawfrey in working on this. He's made it happen. The door can be knocked on, but if you don't answer the door, it doesn't do you any good. And we've made a significant progress on this. We think it's a very valid and concrete project. It's not done, but we can see it done through actions taken in the future. That being said, I would hope that the RBA explains this process to you. The resolution is a notice of intent. And again, as I mentioned on Monday with our agreement, it's kind of putting a jigsaw puzzle together, but we haven't really pressed the pieces together yet. So if we need to remove them, we can remove them. If we need to move them around, we can move them. But it basically gets the process moving. Everyone understands it's a moving process, but that goal is fixed. And that goal is a substantial economic development project to benefit this county. And this is a step to continue that process.
Even at 80%, I mean, we're taking ag ground we're still going to be bringing in a lot of taxes.
Yeah, Mr. Chairman, that pilot or payment in lieu of taxes.
I thought the same thing.
Yeah.
And I don't like acronyms, so I'll call it payment in lieu of taxes.
Yeah.
It can be as low as 10%. You could demand higher. I think 20%, given the scope of this development project, provides
It's
additional
huge.
tax benefit to the county, not just to that area, to the county. And as the abatement drops off, it'll provide a greater benefit to the county.
And while we won't know the actual appraised value until the project's completed, we hire a firm to come in and do a commercial appraisal on a project like this. We just don't have the expertise, and frankly, there may not be anybody in the state of Kansas that does. We may have to look outside the state to do this because it's such a significant project. But it will be, at a minimum, the equivalent of a new city being assessed in the south end of the county, at a minimum. It could be as much as 2 to 3 cities, small cities being assessed down there. So it is significant, even with the abatement, the payment in lieu of taxes, is still a significant increase for revenue for all the taxing entities down there. It's a major project, and
Well,
I think Mr. Van Pers said it's a once-in-a-lifetime opportunity, and it really is.
For any reading ad valorem tax abatement, section 6, talks about the school district. What if the school enlarges?
Commissioners, first off, under Kansas state law, you're not allowed, nor is the school district allowed to pay certain ad valorem taxes that a school district imposes. Capital bonds, things of that nature, can't be waived. The legislature keeps track, a very close eye on what school districts, how they finance themselves, because of various reasons. If the school district enlarges, it depends on, one, how they finance it, and two, I would think it probably require additional action.
Let me ask for a point of clarification. Are you talking about the boundaries of the school district
I'm
enlarging?
talking about, say they build new buildings,
Oh.
new facilities.
Yeah, so under Kansas law, the way that ad valorem property tax abatement works in the IRB context is that the issuer of the industrial revenue bonds, in this case the county, has the ability to consider abating ad valorem taxes for all of the taxing jurisdictions in the county. The requirement is that those ad valorem taxes have to be abated pro rata for all of the taxing jurisdictions. So, for example, the county couldn't agree to abate 100% of the county mill levy, but only 80% of the school district's mill levy. You have to agree to abate whatever percentage of ad valorem property taxes equally for all taxing jurisdictions. Last legislative session in the school finance bill that was passed in May or June, I forget which month, there was a new provision that was included in the school finance law that in connection with property tax abatement, local jurisdictions, cities and counties are not permitted to abate a school district's capital outlay levy. You may or may not be familiar with a school district's capital outlay levy, but there's a provision in the Kansas statutes that allows school districts with notice and a protest period to impose a mill levy of up to 8 mills each year to fund their capital outlay fund. That up to 8 mills, whatever the school district decides to impose up to 8 mills, may not be abated as part of this process. So the specific calling out in that parenthetical of the school district and their capital outlay levy is something that is specifically required by state statute. The way Section 6 is written, all of the other tax levies, and I don't have in front of me the specific number of mills that are levied by the school district currently, but all of the other tax levies would be abated at the same rate as, here 80%, as all of the other taxing jurisdictions that would impose a tax on that site. So any increase in the boundaries or any increase in the mill levy in order to pay debt service on school district bonds, all of that would be abated at an 80% rate. Now, one of the things that we're talking about and what we do recommend to clients is to set the pilot amount at what we call fixed pilots, as opposed to a pure 80% abatement or a 20% payment in lieu of taxes. We feel like that is helpful to not only the local taxing jurisdictions, but also to the company, particularly for very specialized facilities like what we're talking about here, where the assessed valuation of the property is somewhat uncertain because of the specialized nature. And so by setting a fixed pilot, it gives the county and all of the other taxing jurisdictions certainty about exactly the total dollar amount of taxes that will be received, or payments in lieu of taxes that will be received for that 10-year period of abatement. It also reduces or actually eliminates the incentive of the company to come in and protest the assessed valuation of their project, because even if they protested the assessed valuation, they're still going to pay the agreed upon dollar amount of property taxes.
That's 8%.
Well, we would work once we had final plans and we had a sense of what the property value was worth. We would figure out a dollar amount that we believe is equal to 20% of the then current property taxes.
So it would be the actual figure then?
It would be, yes, exactly. Whatever that number.
Right, whatever
fixed
that number is, that would be the figure.
That's correct.
Right.
That's correct. And so there would be a specific contract with a specific schedule saying this is the actual dollar amount of payment in lieu of taxes that you would owe in each of these 10 years.
I guess the next part of my question moves to protection of the bondholders. A great deal of funds used in this are going to buy equipment. Do the bondholders have a lien on the equipment?
Okay, so as Mr. Lawfrey pointed out, the current plan is for the company to buy their own bonds. That
Let's
is,
say they shouldn't.
yeah, it is very, very common that, and in fact, I would say the vast majority of industrial revenue bonds that are issued for property tax abatement are purchased by the company, and they serve no financing purpose for the project. They solely are used to affect the property tax abatement under Kansas law, and that is the only reason why those bonds exist. So there's really no financing
No
risk
gain
or
for
there's-
them to do that.
Right, there's no purpose, there's no
Right.
financing purpose related to the bonds. Now, if the company were to sell the bonds to a third party, typically the entity that buys those bonds is the bank that the company typically works with, because they have all of their other credit facilities that they have to finance all of their operations, and so it is the bank that the company is typically working with to provide all of their other financing that takes this as a piece, buys the bonds as a piece of the financing structure, and instead of the typical loan agreement that they would enter into for financing the facilities, they would buy the bonds, and the bonds would have exactly the same terms as, or very similar terms in terms of repayment and default and all of that kind of stuff as their loan agreements. Now, the reason why that doesn't typically happen is because if the company decides to go work with a different lender and refinance their debt over that 10-year period, they don't want to have to worry about coming back to you guys, getting amendments to the IRB documents and those agreements. They'd rather do that on their own, right? Because you guys are just a conduit for, the county is just a conduit for the transaction. So they wouldn't want anything as part of that restructuring related to their financing to mess up the property tax abatement related to the project. Because from their standpoint, the IRBs are first and foremost the mechanism to obtain the property tax abatement on the real property. As Commissioner Graver points out, I think you mentioned this, under Kansas law, personal property is exempt by statute from property taxation when it's used in a industrial purpose like this. And so there would be no need to issue industrial revenue bonds in order to finance or provide property tax abatement for the personal property. These industrial revenue bonds would only be issued in the total amount of the real property investment that would be made for the project, and the personal property would be handled entirely separately. I know that's a really long, sort of winding, and if I didn't get to your specific question, let me know.
I guess what I was trying to get at, I'm thinking of John Doe out here, if he should end up holding some of these industrial revenues. The way this is written right now, there would be no lien on the equipment within the major building.
Yes, that's absolutely true. The way the industrial revenue bonds are structured, the bonds are payable solely and only from lease payments that are made from the company to the county. And it is a lease of the real property that would be involved. There are two ways to get the underlying security to the county. You could either have the company own the fee simple interest in the land and enter into a base lease with the county for a term of years. Usually that term of years is 1.5 to 2 times the term of the underlying lease. So in this case, the financing lease would be 10 years, so the base lease would be 15 to 20 years. If the company were to default in the lease to the county and those payments that are used to repay bondholders, in the base lease concept that I talked about, which is the most common circumstance, then there would be a trustee bank that would be holding the county's base lease interest, or that 15 to 20-year interest in the underlying real property, and bondholders would be able to ask the trustee to go out and relet the facility or find other revenue-producing uses of that facility for the remaining term of the base lease in order to attempt to generate revenue to satisfy bondholders. But in no event would the county ever be on the hook for repaying any of those funds. But at the end of the day, that is the security that is available to bondholders if these bonds were to be issued to the public or some other third party. That would be very, very fully disclosed in offering documents, and so that investors would clearly understand what security they ultimately had there.
Yeah, because if you don't have it that way, then the person buying the bonds, he's going to look at that and say, oh, I don't want those bonds. I could be on the hook for those. But this way, he's not on the hook for them. He does get his payments.
Assuming that the trustee could find an entity that would be willing to come in and take a lease of the facility for the remaining term and generate sufficient revenues in order to repay the bonds, yes.
Right.
Go ahead.
We have no limit on the equipment put into that.
That's true. That's true. And I will say that where you have third parties purchasing the bonds, it is usually highly sophisticated, large institutional investors and or the banks that are providing other financing to the company. It is very common that there would be a sort of overarching collateral agreement or security agreement that would basically cause cross-default provisions among this IRB and all of the other security or credit facilities that the company would have for their other assets, including the personal property that may be in the facility.
One thing that I just want to ask for general purposes, because of some of our past projects have always had to go for an AG's opinion. Does the AG have anything to say about this? Do we have to go to them for approval or disapproval or whatever?
The Attorney General does not review industrial revenue bonds, the transcripts for industrial revenue bonds, or any of the bond documents related to industrial revenue bonds. The AG also does not review the development agreements between the county and the company related to the property tax abatement or any other incentives that may be provided.
I just wanted to put that out there so that we don't get our hands slapped again.
The state is involved because the Board of Tax Appeals must grant the tax abatement.
That is correct. So the process here that we would follow, as Mr. Van Perry's and Mr. Locker referred to, there is a requirement for a cost-benefit analysis to be prepared, for there to be notices to the taxing jurisdictions, for a public hearing to be held by this board on the granting of the property tax abatement. Once that process is completed, then you would adopt another resolution that would officially evidence your intent and remove all of to grant the tax abatement and remove all of this conditions for the notice and the public hearing. At that point, what typically happens is that the company begins constructing their project based on your intent to grant the property tax abatement. The actual industrial revenue bonds are not typically issued until the project is very near completion. So for example, if the project were to be constructed in 2018, we would not go ahead and issue bonds by the end of this year because the abatement that's granted is for a 10-year period and it begins the year after the industrial revenue bonds are issued. And so if we were to issue the bonds in, say, December of 2017, the abatement period would begin in January of 2018. If the property hasn't been improved at all, then the value of that abatement in that first year is not worth a whole lot, right? And so they would rather have the first year of abatement, let's say they're nearing completion or almost completed at the end of 2018, we would issue the bonds before December 31st of 2018, and then the first year of abatement would begin January 1 of 2019 when the full or nearly the full improved value of the site was in place at that time in January 1 of 2019, and the abatement would continue then for 9 more years. And so getting back to the timing issue and approvals required by the state, there is a requirement that we give notice to the State Board of Tax Appeals at least 7 days before the industrial revenue bonds are actually issued. So we would give them that notice. There's no approval or disapproval process. We just have to tell them that we're about to issue the industrial revenue bonds. And then what would happen is we would make application to work with the appraiser's office to make application to the State Board of Tax Appeals. Usually it happens in about the first quarter, that we would get all of that paperwork together, and then we would send that to the State Board of Tax Appeals in first to second quarter of, in my example, 2019. The State Board of Tax Appeals would review that documentation and then approve or deny the property tax abatement. It is rare that you would see the State Board of Tax Appeals deny an abatement. It really is just a review to make sure that all of the statutory requirements for the type of facility that is eligible for property tax abatement, that's what we have here. And then they're also required to issue their order so that then when the tax bills are sent out, that order is the basis for a zero property tax assessment and the resulting pilot that you've agreed upon.
During this period, the company that's building the building and buying the equipment has a sales tax exemption. How do they get that?
So there's a couple of different ways that a sales tax exemption may be obtained. Any property that is purchased with industrial revenue bonds is eligible for a sales tax exemption on the construction materials. And so as soon as we have gone through the public hearing and that resolution, that second resolution of intent that I talked about is approved, then at that point the sales tax, the county is able to apply for the sales tax exemption that they can then give to the company. That process is only required, though, if a sales tax exemption is not otherwise available under statute. My understanding is that a sales tax exemption is otherwise available under state statute for this project, and so the county won't be providing the sales tax exemption for construction materials on the project by virtue of the IRBs. It would be a possibility, but my understanding is that's not required because they are otherwise able to get the sales tax exemption through the state and the statutory provision that the state can offer.
So this is just for, say, the building. What about the Atmos Energy that's coming forward, and they're going to have to put in lines, and Suburban Water, who's going to have to put in lines? Would they also get the sales tax exemption because they're going to use materials for this project?
That would be a separate process because it is their property and their lines. They couldn't, say, piggyback on the exemption that is being provided to the company. So we would have to go through, they would either have to have their own sales tax exemption under state statute,
Right.
Or we would have to go through the process related to potentially industrial revenue bonds for those facilities. in order to get the sales tax exemption for that equipment. That is one thing that we have discussed and are still exploring to work through some of the logistics with that. So I don't have a good answer for you right now, but we're working on it.
Who does the cost benefit analysis?
We'll hire that out to a financial advisor.
Okay.
Who pays for this financial advisor?
We're allowed to reimburse ourselves through this issue.
Commissioner Graber, members of the commission, the county is allowed to pay the costs related to the issuance of these bonds out of the bond proceeds. So it's not out-of-pocket expenses we're looking at. Been visiting with Mr. Lofrey on this. He's identified several financial entities that could serve as your cost-benefit analysis provider. We can certainly seek guidance from Gilmore and Bell on that matter. And I think Gene raised a very valid point. I think Mr. Lofrey initially did, I did, and I think it's in the RBA. There are a lot of additional steps that can be, will need to be taken as part of this process. And the permutations of possible steps is almost infinite. But we're trying to keep this as straightforward, traditional, as simple as possible. And each Atmos will have certain options that are available to it. It's up to them to choose those options. Same with Suburban, same with the customer. And the county does need to be cognizant of those options and work with them as they make those choices.
So they would be notified of these options through the county.
They could, or I'm certain they're aware of them as they exist right now.
Right.
Well, I'm sure we didn't get here today without somebody doing a cost analysis of this area in this company, or this company doing it, or even at the state level. I mean, is there other, or we be able to find out if anybody's done that, and we'd be able
No.
to use that same company or
Mr.
something?
Chairman, all I can tell you, it was not done by throwing a dart at
Well, I'm pretty sure it wasn't. And I'm sure there's been a lot of studies done before we got here.
For the IRBs, you have to do a specific cost-benefit analysis that's required as part of the process. So we wouldn't be able to use something that somebody else has already calculated. As far as the financial wherewithal of the company, that I think as things move forward, you'll see that that's not going to come into question. They're the largest in their industry, the largest. They're largest in the world in their
Right.
industry. So it's not a startup. It's a well-established company that's traded on New York Stock Exchange.
So,
So they are financially well off, and this won't be I don't think you have to worry about that part.
Okay.
But the cost-benefit analysis will be whether us doing this abatement has a return to the county that's equivalent. And obviously with the pilot, that takes away a lot of that weight. Preliminarily, I don't see an issue with that.
okay. I guess I'd like to hear from the county clerk. Do you have anything to add to this?
Oh, I don't.
Okay.
I think it's a project that you should move forward with. I feel very confident in what Mr. Lockery and Mr. Van Harris and Ms. Rekoff has come up with.
Do you have no concerns?
I have no concerns.
Okay, so I wanted to hear. Anything else, commissioners?
I had a list of questions, and part of them got answered when Clyde was asking, and part of them got answered when I asked. So
We're good.
I've got my questions all answered. I'm sure I'm going to read through this and have more questions.
I hope so.
And Commissioners, certainly we anticipate questions. That's why we're here to answer them. And if you don't ask questions, that kind of concerns me more.
Yeah.
So, and please ask them.
I read through the documentation that Gilmore Bell provided,
Mhm.
or David did
I
through
think it
Gilmore
gives you-
Bell. I read it several times.
I think it gives you an overall picture. You
Right.
can make these transactions as complex as you would like. I suggest you make them as simple as you need, and that's the goal we're going to work for, is just get it done. If there are variables that need to be dealt with, we'll deal with them. We don't wish to raise any additional ones, but if they come up, they'll be addressed. In closing, I would just like to state this is, I think, a substantial opportunity to the county. I applaud you for having reached this point and proceeding forward, and the way to proceed forward would be to adopt this resolution this morning.
One last question. Is the property in question Is it under contract?
My understanding is that has been resolved. We wouldn't be part of that
No,
agreement, but they've been in negotiations for about a month and a half on the property. And my understanding was yesterday they were to have had everything signed. But again, if for whatever reason that falls through, this doesn't obligate us to anything.
We're not obligated on anything if something falls through.
Correct.
Commissioner Holland to address that, per your directions, Ms. Rykoff and I have been following Mark's instructions to expose the county to the minimal amount of liability that is available to you, and I think we've done that and we'll continue to do so.
You need a motion for approval of the resolution, is that right?
Correct.
Do we have a resolution number?
2017-52.
I move that we approve resolution 2017-52.
52. Second.
Voting.
Aye.
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 Commissioners, I thank you, and you'll be hearing about this topic.
Thank everybody for all their hard work they've done to get us this far. Mark, you have anything else?
That'll do it for me today.
All right, motion to adjourn. Second, voting. Aye.